You're back on your medications? Have things kind of leveled out for you? And are things going good at your job? The mitigation report describes your peers as saying that they consistently describe you as caring, reliable, and helpful. That certainly wasn't you this particular day, at least as I read in the report. And I don't want you to make a comment on that. But do you understand my concern with putting you on a period of probation that's going to basically allow you to erase your record? Do you understand that concern I have?
Yeah, I understand.
And again, without any, she's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground and then had the gall to post another video of it on TikTok. I'm going to be very honest with everybody. I don't plan on following. Heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in the place of confinement. Now, along with that, there's what's called a Killebrew agreement, and what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence, and if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand?
I asked the court to place Ms. Jones on a delay of sentence up to
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Were there charges on that?
She reached 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Oltz, because I had a conflict on that because I was the elected prosecutor when that arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court or somehow tied with other events. I'm not going to make a decision today What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept on. How is your daughter doing?
She's doing good. I mean, it affected her, you know, but
How so did it affect her?
just being out, walking around town, she didn't deserve that. She'll get through it.
Okay. Anything else you'd like me to know?
No.
Okay. Thank you for coming today. You can go back out.
One thought that came to mind throughout this case was the saying that hurt people. I do recall a case where Ms. Jones was a victim of felonious assault, and then it's unfortunate to see her as the perpetrator in this case. My hope with this plea offer, would be that she could be rehabilitated to break that cycle.
Ms. Jones, you had the right to address the court before sentencing. Is there anything you'd like me to know?
I'm very sorry. I never intended to hurt her. I was trying to work right now. And I even myself was very shocked seeing the video. And I'd love to get into
You'd love to what? I'm sorry?
anger management classes and more help.
Well, I know you've been through a lot, and I'm familiar in the various roles I've had of the different issues that you've had. And now that you're back on your medications, have things kind of leveled out for you?
It's going
And are things going good at your job? The mitigation report describes your peers as saying that they consistently describe you as caring, reliable, and helpful. That certainly wasn't you this particular day, at least as I read in the report. And I don't want you to make a comment on that. But do you understand my concern with putting you on a period of probation that's going to basically allow you to erase your record? Do you understand that concern I have?
Yeah, I understand.
And again, without any comment because of the no contest plea, at least the way the report describes, you went after this girl pretty hard. And it sounds like she had some effect from that based on what her father said. And as I said before, the law is designed to recognize that young people in certain situations do stupid things. Not that I find that this was excusable by any means, or that this was a stupid thing. This was you physically attacking a 14-year-old girl over a comment that was made about somebody else's mother, deceased mother. And then if I recall correctly, there's quote unquote round 2 video for TikTok. Yourself were a victim of a felonious assault. And if I remember correctly, Mr. Carnes, was that the gun being pulled on her?
Yes, sir.
And then you turn around and assault a person who's 5 years younger than you. And you're an adult. She's 14 years old. But at the same time, I realize that you have a struggle aside from this that you need to overcome. And I don't necessarily want to saddle you with anything further. I am a firm believer in allowing people to shape their own destiny, so to speak. So I am going to follow the recommendation. I'm going to put you on a delay of sentence for 12 months. That's the longest period I have available to me. If you're not successful, the conviction.
I think I can't do it in the jail. I know I'm 19, but I'm behind, a couple years behind, and I would like to catch up and live peacefully and happily and get a better chance at life. I don't want to end up this week here.
I do find that she is still a threat. She went to somebody's house, at least allegedly, to get her earphones and wound up.
Personally, I think the most frustrating part of this case is that Miss Jones was given exactly what so many defendants ask for, the second chance. The judge had serious concerns from the beginning, but still chose rehabilitation over immediately leaving her with a permanent conviction. Then, just 1 month later, she was back in court facing another alleged assault. At some point, second chances have to come with accountability. Her age and personal struggles may help explain some of her behavior, but they don't erase the impact on the victims. Let me know what you think. Did the judge show too much mercy, or was probation still the right decision? Don't forget to like.
The most powerful moment in this hearing came when the judge completely stopped the proceedings to question the plea agreement. Even though both attorneys supported a delayed sentence that could eventually erase the conviction, the judge wasn't convinced. He pointed to the disturbing video showing an 18-year-old repeatedly kicking and striking a 14-year-old who was already on the ground in a fetal position. What seemed to concern him even more was the allegation that another TikTok video was later posted with the caption "Round 2." For the judge, this didn't look like a simple lapse in judgment, it raised serious questions about accountability and rehabilitation. In the end, despite his concerns, he still gave the defendant one final opportunity through probation, showing just how difficult the balance between punishment and second chances can be.